We are close enough, I think. We will call to order the 148th meeting of the Massachusetts Gaming Commission, once again at the Convention Center. I'll mention this again, but lest I forget, our meeting in 2 weeks will be at the Hines, not here. So for our regular in-person followers, you should note that. We will go, as usual, first to the approval of minutes. Commissioner McHugh.
Mr. Chairman, the minutes of the March 19, 2015 meeting, our last meeting, are in the book, and I would move their approval as they appear there with the usual reservation of our power to correct mechanical and typographical errors.
Second?
Second.
Discussion? I did notice that there's a misspelling of our new interim racing director's last name, which we could fix.
We will fix that,
Yep.
Mr. Chairman. Thank you.
All in favor?
Aye.
Opposed? The ayes have it unanimously. Just so we don't have our meeting with any elephants in the room, I want to pull item number 9, which is other business not anticipated at the time of the setting of the agenda, forward. There was a story today in the Globe about the issue with the MBTA transfer of its land to Wynn. And meanwhile, the MIPA process is going on, or a MIPA decision is expected maybe as soon as this week. And I just wanted to check in with Commissioner McHugh, who has kind of led the way for us on this, to see whether there's anything that we need to be concerned about or think about in either apropos of that story or just the MIPA process in general.
Well, Mr. Chairman, I think that the important thing for the Commission to think about is that this is an important and comprehensive process. It's running its course. We have made provisions for it in the license that we awarded. Our regulations contain provisions for it. And the bottom line is that however that process winds up is in the hands of the Secretary of Environmental Affairs at the moment, but after that process does finish, then the Commission is required to and will take another look at the findings that issue from the appropriate secretariats and the Secretary of Environmental Affairs, make its own review of issues as they then stand, make its own findings, issue those findings and any additional license conditions that are necessary. And until that step is taken, not a shovel goes in the ground. So that process has to run its course. It's an important process, but we've made provision for it in the license that we've issued in our regulations, and we intend to stick with both those license conditions, the provisions of our regulations, and the importance of the review, which we'll look at when it's on its course in the other jurisdictions.
Great, thank you. Any other thoughts or reactions? Okay, great, thank you. Now back to item number 3, administrative update, Executive Director Day.
Good morning, Chair Crosby and fellow commissioners.
Good morning.
Morning.
I did want to start this morning with just a little note. It's kind of a note of sadness because, as you may know, Danielle Holmes, our staff attorney, and who does a lot of work with racing as well, this is her last day today, so we thought it might be appropriate for the commission to recognize her. And rumor has it that she's back in the back. I can't see behind me, but
She is in the back. I can see her back there.
Stand up, Danielle.
She's trying to hide back there, but she's here.
You'll be missed. Tell everybody where she's going.
going to the New York Racing Commission, last I was aware.
Right. So be in
Racing and gaming.
Racing and gaming.
Racing and
yes.
gaming, right. Wow. Doing a lot of work in this business and be actually out in Saratoga, right? Living in Saratoga.
Mm-hmm.
So Danielle has done a terrific job. She was, I think, the first, one of the early non-commissioner support staff people we hired, probably the 8th or 9th person of the commission group back when we were smaller, and has done a terrific job, first in racing, and I know Commissioner Cameron can speak to that, but then moved over into the legal department and has been a stalwart there, both in working with regulations and working with the the hearings on regulations and working with the hearings on appeals from racing decisions, and in being a general lawyer assisting wherever assistance was needed in the commission's operations. So we all will miss you very much, and wish you the success we know you'll achieve in the new setting and the new operation.
Well said.
I second all that. My only regret, besides your leaving, is that I never got to see you race. She's a jockey, too. Thank you, Danielle.
Commissioner Crosby and Commission, at our last meeting, you might recall, I did identify that we were looking for temporary space, and we had kind of found a location that would look pretty well in Springfield with UMass, and that was even more appropriate because we already have a relationship with UMass relative to a research project. What has happened since then is we did receive a very reasonable proposal from UMass Center in Springfield. We would like to be able to go ahead and proceed to obtain that, to sign that lease and move forward with that office space during the period while we're kind of assessing what we're going to need over the long term. And I just wanted to check in with the commission, and if I see no objection, we would move forward with that lease.
I don't want to say I wouldn't just characterize it as reasonable, because, I know you'd all be jealous and want to move the entire team out to Springfield knowing what kind of rental agreement we have. But thanks to the folks at UMass for their partnership in this project and their flexibility, and look forward to working alongside them. It's going to be space available to not only myself, but to all members of the commission if they're out in Western Mass, all members of our staff if they're out in Western Mass, and also has suitable conference and meeting space too, should we require it for any purpose. And that's all built into the $200 a month rent we're going to have to pay.
Great.
Yeah, I was hesitant to mention that because I didn't want to interfere in tenant relationship overall, so I thought I just left that on the table, but it's a very reasonable rate. And
It's competitive for the market in Springfield. Let's leave it at that in case the lease has to be renegotiated.
Is there space enough for our meetings when we go out there?
There's some space that would, yeah. I think there's suitable space
That
that
might
we
save
could,
us a few bucks, too.
yeah, there's some suitable space that could probably, depending on the agenda,
Right.
house everybody. Sure.
Great. No, I think that's terrific.
we will proceed with the lease.
Great.
The next item on the agenda today is relative to Regency. Michael and Carol, I just will let have Michael and Carol come up front where they're handy. What we had anticipated on this particular item was to reevaluate relevant market changes, update information regarding tribal issues, and then also may possibly do some discussion in the light of the 45-day extension to discuss potential impact on other critical areas. I want to note as we get into this topic, tab 3A, we've also received 4 letters. Those 4 letters have been made part of the packet. One from New Bedford attorney Leontire and Beauregard, New Bedford attorneys, was received on 3/27. One from John Donnelly and Neil Bloom, received on 3/30. Brockton Mayor Bill Carpenter on 3/31. And recently Rob Scarpelli from HLT on 4/1. The commission also under this tab is also a letter that was sent by the commission to Assistant Secretary Washburn from the BIA inquiring about the status of the tribal application for trust. Michael and Carol are also here to offer some comments at the commission's discretion. As we talk about the schedule issue, I just want to leave on the table for the commission, one possible method to deal with the schedule as we look forward is to wait until after the May 4th date and then ask staff to take a look at the number of applicants that we have, and then come back to the commission to have a discussion on specific dates that the staff might recommend in order to deal with special circumstances, or to deal with things like the IAB investigations, host community relationships or host community agreements, and those kind of things that take a little bit more time to figure out how the rest of the schedule is going to work. A note with that would be that the date would be at least 45 days from the current RFA2 date, similar to what the commission did with its requirement to have complete documents submitted, which, just for reference purposes as you begin your discussion, would put it about July 10th. So with that, I'll
Let me
turn
just,
it over to the Commissioner.
Yeah, let me just add a little bit to that. First of all, on the schedule issue, just to reiterate, I think that's a good suggestion that we'll finalize the entire RFA2 schedule once we know how many applicants we have. Obviously, it'll vary depending on how many we have. But, as you said, but I want to make sure everybody heard that we will, at a minimum, extend the RFA2 date by the same 45 days that we extended the RFA1 date. There may be more, but at a minimum, anybody who's working on that knows that there's at least a 45-day change.
So does that take it to July 10?
To July 10th, yes.
Okay. So that's the minimum extension is until July 10.
Correct.
The Commission could opt for the next business day, which would bring it to that next Monday.
Okay,
July
okay,
10th.
but,
Right, effectively.
okay.
And then on the issue that's on the agenda, the Regency update, Commissioner Cameron explicitly raised at our last meeting the issue that there have been a number of changed circumstances in the Commonwealth and surrounding states, even in Region C, since we had done some of our work. We are mindful of the need to constantly do our due diligence on the process here, as she in particular and Commissioner Zuniga pointed out. There have been calls for us to alter our plans in Region C from the outside. Some people want us to change, some people don't, but there have been people who said we ought to slow down. So we agreed with Commissioner Cameron that it made sense to take a quick but rigorous re-look at the underlying circumstances, principally the economic circumstances and the tribal circumstances, to see whether or not we wanted to change the plan that we were on. That plan to date has been that we would proceed with the commercial application, and at the end of the commercial application, once we knew what we had, we would then make a decision on whether to award, and if so, to whom. Should that be reconsidered? We have asked both of our principal consultants to help us with this review, and we're going to have Commissioner Zuniga characterize the report from our economic consultants, but as long as our friends Michael and Carol are here, why don't we start with your sense of to what extent and to what relevance there are changed circumstances relative to the tribal situation in Region C.
Thank you, Mr. Chairman, members of the Commission. As you pointed out, Mr. Chairman, the Commission has asked us to be present today and to give you a brief and summary overview of the tribal circumstances as they are present today in Region C, to assist you in any way we can with respect to the decisions that you need to make. We will attempt to give you just a look at the processes and an overview of the legal issues that arise out of that situation. We'll start with what we can't do, and what we certainly cannot do is to opine at all on the merits of the tribe's application at the present time pending at the Bureau of Indian Affairs, or on the timing of when the Bureau of Indian Affairs may make a determination on that application. But what we would like to do is describe the environment in which that application will be considered, and the procedures that will be attendant to it. So what we'll start with, we thought was a logical place, is the nature of the compact and any changes in the state tribal relationship in that regard, and Mr. Carroll will take care of that part.
Thank you. Good morning, Commissioners.
Good
Good
morning.
We,
Say your name, Bob, just
pardon?
for your name, just for the record.
Oh, I'm sorry, Robert Carroll from Michael and Carroll. We have looked at the compact. As you're aware, back in 2012, the initial compact that had been proposed was in fact disapproved by the Bureau of Indian Affairs. Since then, there has been a new compact that's been in place since February of 2014, and there are some changed terms in that document. Essentially, the allocation of regulatory duties, the co-regulation, if you will, pretty much stayed intact, but there is a financial term that we felt is significant in terms of change, and that has to do with the potential that if the Commission should issue a license in Region C, a Cat 1 license in particular, and if gaming operations are commenced in Region C, that there would be a reduction in what the tribe would otherwise be required to pay in the under the compact's revenue allocation terms. The original percentage was 21% that was agreed to, but that would be if there was no gaming in the Commonwealth. Of course, there is in Region A and B in terms of the issuance of the license and the intendment of the commencement. So you would pretty much be involved with the reduction from 21% to 17%, which is the operative number that has been added to the new compact.
17% in the event that there is no commercial Category 1 license in Region C.
Correct.
Yes.
And the impact of that particular change in the compact obviously factors in to a certain degree in terms of your review. However, regardless of the revenue allocation change, the tribe is still obligated to pay regulatory fees for the co-regulation and a variety of other items in there, including taxes and other areas that don't fall directly on the tribe and its members. A variety of those carryover terms were carried into the new compact. The net effect of the 17% provision, it's important to distinguish the issuance of a license from the commencement of actual activities. As you know, the gaming activities require some ramp up. You're undergoing that now in Region A and B. That involves a substantial amount of time for the development and the construction phase. And in the tribe's case, that can't even commence until after the land and trust issue is resolved, which we know has, at this point, no predictable date. The licensee, the state licensee, on the other hand, if you choose to go forward, does not have to wait in that regard, does not have that additional hurdle to handle. And there are other tribal obstacles, or I should say hurdles, that will have to be dealt with, and that includes NIGC review of a management contract, and the various other NEPA and MEPA considerations that go with a management contract review as distinguished from the initial land and trust application. All of this obviously regrettably engendering delay if that particular process was followed. For the purposes of our discussion today, though, and not getting into the weeds further than necessary and separating out the particular financial impact that I know Commissioner Zuniga is going to talk to from the HLT analysis, the 17% insertion under the provisions that it's in there with not taking effect until the commencement, we believe, as we'll discuss in the recommendation section, does nothing to impede your continued process at this point. But we'll elaborate on that a little bit further as we go along.
If I didn't say it before, Guy, Michael, and Carol, and I apologize for the Twilight Zone ringtone. That's my daughter. If you knew her, you'd understand. What I'd like to do now briefly is to just give a general picture of the environment again within which the BIA is considering and making its decision on the land in trust application that the tribe has submitted. When we say land in trust, and we all know what we're talking about, but just generally, the federal government in 1934 passed legislation that allowed it to essentially take land in trust for tribes. That in the past, the federal government just grabbed land that the tribes had previously owned. In order to remedy that situation, they passed this legislation, which then allows tribes to actually control land, but it's actually legally owned in trust for their benefit by the federal government. The act in 1934 that authorized that process defined the tribes that they would take land in trust for as recognized Indian tribes now under federal jurisdiction. And for 75 years, everyone thought that what the word now meant was that when a tribe applied for the land in trust, if they were now under federal jurisdiction, they could get the land in trust. 75 years later, the Supreme Court disagreed. And in a case called Carcieri versus Salazar, the court ruled that the word now means in 1934. So since that decision, for any group to be able to have the federal government take land in trust for them, that group has to establish to the BIA that they were under federal jurisdiction as of 1934. in terms of the changes that have occurred in the past 2 years, there really haven't been any changes to that rule. The Carcieri rule still applies, and the Mashpee Wampanoags will have to comply with that rule in order to have their land taken into trust. What has changed within the past 2 years, if it's really can be considered a change, are that there have been some cases that have been decided which might give some guidance to the possibility of any kind of outcome, although the cases go all kinds of different ways and they don't really give us that much of a milestone. One of the principal cases is one called Big Lagoon Rancheria versus California, and that's particularly interesting because the Ninth Circuit there ruled that the state was correct in refusing to negotiate a compact with the tribe because, as the state asserted, that tribe had not been under federal jurisdiction in 1934, therefore it could not have land in trust, therefore it wasn't Indian lands, and therefore they could not have a casino. What's interesting about the case is that the land already was in trust. The BIA had agreed to put it in trust, but the court said the BIA was wrong and used the wrong standard, and therefore essentially overruled the BIA's determination. That was a 3-judge panel of the Ninth Circuit that was then petitioned for rehearing before the full circuit was filed, and that case is now still pending. That has, it was briefed in September, arguments were heard in September, and hasn't been decided yet. Another case situation is the Cowlitz tribe in the state of Washington, and in that case, there were 152 acres of land that the BIA eventually took in trust for the tribe, even though the tribe was not recognized, federally recognized, until 2002, obviously long after 1934. It involved an extensive analysis of the tribe's relationships to the federal government throughout its history, the extent to which it had communications with the federal government, any financings that had been provided by the federal government. All of those are criteria in the BIA's determination of whether or not land can be taken into trust under the Carcieri standards. Those BIA records went back to the 1855, 1860s. They really, they delve very deeply into that. So it's a very fact-sensitive determination. Once the BIA makes its judgment, though, that's not always the end of the process. There are a number of ways that those decisions can be challenged, and this is something that has happened. If it's within the past 2 years, it's close to within the past 2 years. And that's a case called the Patchak decision, and it involved a challenge by an individual to land in trust determination that was made by the Band of Potawatomi Indians. And in that case, the Supreme Court expanded the zone of interest for people who are capable of making challenges to BIA land and trust determinations. Previously, only state and local governments could challenge those determinations. Under the Patchak case now, interested persons can do that. The way the BIA handles that Patchak decision is that during the course of the land and trust process, anyone can file with the BIA and say, I'm interested in this, and I want to be noticed about all the determinations you make and give me notice of your final decision. They become, quote, interested persons. Then when the determination is made, if any of those interested persons decide they want to sue and challenge it, the court will make its own determination of whether or not those persons, even though they call themselves interested, fall within the category of interested persons that the Supreme Court established in the Patchak case. But it does, whether or not ultimately these either the budding landowners or others that have some modicum of standing to challenge the BIA's decision regarding any particular tribe, there is the expanded possibility of challengers in that regard. There is also, in 2014, the decision of the Supreme Court in the Bay Mills case in Michigan. And in the Bay Mills case, to even complicate matters further, because a tribe had built a casino outside of its reservation, not on Indian lands at all, not on land in trust or reservation land. It was outside of any of the legal categories that would allow them to build a casino. The state sued to have the casino closed, and the Supreme Court held that the state had no jurisdiction to stop them from building that casino because of the tribe's sovereign immunity. Ordinarily, the National Indian Gaming Commission would be the party who would also come in from the federal government to close down a casino that was not properly authorized. But the National Indian Gaming Commission took the position that all their authority only extended to Indian lands. So you have a casino that's clearly not on anything that's authorized for them to build it on, and the two main authorities, the state and the federal government, were prevented from closing it. This did not mean that there was no remedy. The Supreme Court said you could either sue the individuals who are running the casino, the tribal officials, because they're not the tribe and they're not cloaked with the same tribal immunity, or you could take criminal action and arrest everybody who's in the casino. That's what the state is going to do as a result of that decision is still up in the air. So
What state was these guys?
this is in Michigan.
Michigan.
Yeah. I don't know that that clarifies anything. It probably makes it a lot muddier, and that's probably our point. There's no real way to make definitive predictions about the state of the law today, tomorrow, or 10 years from now, nor the ultimate resolution of the merits of this application. But what we what we would recommend is our conclusion with respect to the overall issue here is that waiting at this point to see what's going to happen would probably not be productive. That the unpredictability of all of this is something that could last for a long time or be cleared up tomorrow. So waiting for that resolution it would probably be a detriment to all the parties involved. That's our view, and we leave it to you to make that determination.
Mr. Michael, I think the only thing clear as far as those cases are that every single one, after a decision was made, was challenged, correct?
That's right. All of those were challenged. And it's almost universal that, especially land and trust determinations involving gaming, end up being challenged one way or another. There probably are a number of land and trust applications that do not involve gaming, where the Indian tribe doesn't intend to have a casino on that land, that may go through. But gaming decisions are very controversial, as I don't have to tell you.
Is there any, I know this is another hard to predict, but can you make an informed judgment about if there were a land and trust award and there were a suit, which is a pretty high degree of likelihood, whether development of the tribal facility would be enjoined until the legal action was resolved?
It could depend on the degree of potential harm to the particular plaintiff that could be made, the case that could be made. I think it's certainly a reasonable chance, that there would be some enjoyment of the progress of it. Which is one of the key factors that we focused on in looking at all this, which is the amount of time that it takes from the time that a license is approved and the actual commencement of gaming, as you know from the Region A and B, can be substantial. And one of the purposes here, obviously, has been to commence revenues coming to the Commonwealth as soon as possible. And looking at the status of the legal decision area, where it's clearly murky, coupled with the fact that the processes that would be needed, additional processes that we need, can't even commence until that land is decided upon, builds in delay that is just way too unpredictable for you to, premise further delay on your part in terms of holding up the license. We do note, obviously, the patience that the Commission and the Commonwealth has shown and has been working closely with the tribe That's been acknowledged to us by the BIA, that, you know, everyone appreciates the nature of the relationship and the fact that the parties have tried to do what they can for the Native American interests here. But the interests as a whole of the Commonwealth can be affected if the delay is hinged on this unpredictable legal situation that faces you now. And, you know, it's our feeling that looking at the entire situation, that the going forward with a commercial license at least gives you some surety of progress. You know, we think it is in the best interest, but that's just our recommendation.
You know, I'm particularly intrigued by the Bay Meals example. The Bay Meals, because I guess on a first level, that was the example that I'm the least familiar with, or that I was the least familiar with. But it's also, isn't Patchak also a Michigan decision? It's a Michigan case?
I don't,
That was a, well,
I'm not sure.
Here's my point, or my question rather. Was there a compact? How did the tribe proceed without land into trust?
They just built the casino, and the state had sued to prevent it. It went all the way up in the course of the proceedings.
Right.
It went all the way to the now. It wasn't entirely built. As my understanding of the facts, that they may have gotten an injunction, but it wasn't completed. I don't think it
Okay.
wasn't an operating casino when it got to the Supreme Court. Is my recollection.
Okay.
But they intended to go forward with it, and the Supreme Court ultimately ruled that not that they could, but that there was no one to, in a regulatory sense or basically a civil sense, stop them.
Right. But because this is the one case that's different from all others, right?
This is the only one that I'm aware of. Where
Because
that
the others have
that
been
happened.
challenged for,
before
you know,
land in trust.
before they can begin
Right.
by a person of interest or
Right,
the
and
state.
There's
or,
no indication that that situation, the Bay Mill situation, would be present here. We bring it up only in terms of
To show the
the
complication.
uncertainties and the unpredictabilities of this area, and especially since the past 2 years.
Yes.
Anybody else?
Is there a, you know, Carcieri was kind of the driving decision, starting to tie up a lot of these land and trust applications. What's the scenario or environment in Washington right now to find a Carcieri fix?
There's a bill that has been introduced by Senator Tester from Montana. He was the chairman of the Indian Affairs Committee, he's a Democrat. Now he's the ranking minority member. It's essentially the same bill that has been introduced a number of different times and has not gotten anywhere. There's no real indication that this will be, again, it's not, it's even harder to predict Congress, I guess, than it is to predict the BIA. But if the past is any guidance, then this doesn't look like it would have the same lack. It does look like it would have the same lack of success. The tribes obviously are very anxious to have this fixed, but the opposition comes out of states where, ironically, there is already a lot of tribal gaming, California in particular, and the fear that this would just open things up to even more, and not only more, but more in cities and areas where people don't particularly want it. Senator Feinstein, for one, has been very vocal in her opposition to any of this.
Do you know the current, what's the current population, I guess, of awaiting applications, both for simple land and trust obviously for gaming purposes?
I don't know the number of applications. Well, if you know, I know that the president has taken the position that he wants, by the end of his term, for there to be 500 acres in 500,000, yeah, 500,000 acres in trust. There's now only somewhere around 300,000. So it's the administration's position to incentivize the BIA to agree to take land in trust. And Bob and I were both at a meeting of the BIA in Nashville last week, and they were encouraging tribes to make applications because they want to satisfy the administration and meet that quota. So there is an effort ongoing to try to do this. The problem is that they also told us that they are sorely understaffed, and they are not able to get to a lot of these applications for a variety of reasons, staffing being one, and the complications of them being another, and so on. So I don't know if that's an answer. That's the circumstance. I don't know that. Do you know anything about the number?
Well, no, what the numbers you cited are obviously accurate. The only other aspect is that, part of their process includes that after an application is filed, notice goes out to affected local governments and tribes and so forth in the area for comment. And, one of the effects you have is obviously Land and Trust takes that land off of the local tax rolls. So you're always going to get response in terms of how it affects the local community, because in some local governments that can be significant depending on what's taken into trust. The simple applications that don't involve gaming are the kind that they have been, their performance since the president's incentive, they have every year produced so many acres. This year, up to this point, I think it was 250, something like that this year. But there's 300,000, there's about 200,000 left in the incentive stimulus that was given. But a lot of them would be taken up with simple applications, not complex ones that would involve, gaming interests and things of that sort. Because once you add gaming into the mix, obviously you have all of the mitigation impacts and mitigation and impacts that occur with a larger facility. The simple applications, taking agricultural land in or land in for residences and things like that, even those, require notice and so forth, and the steps that are taken, coupled with the understaffing that the BIA has been struggling with, causes, quite a bit of delay anyway. But the backup, if you will, is what it is. There are many applications, and they are working diligently. I mean, we got the impression they're doing everything they can to get it done, but, there's a lot of pressure on them right now.
One other piece to this part of our inquiry, we, again, pursuant to Commissioner Cameron's suggestion that we ought to exercise whatever due diligence we possibly could to inform our decisions on this, we wrote, as Director Day said, we wrote Undersecretary Kevin Washburn, who was the Undersecretary of Department of Interior, who, among other things, is responsible for the Bureau of Indian Affairs, explained our situation, explained our dilemma, explained the time frame, and asked him for a meeting or a phone call where we could see whether he could tell us anything about the time frame of the decision-making process. He called me on Monday, and here were his reactions. First of all, he said the Mashpee application remains a high priority for them. He said there has been no final decision. The issue essentially is, do we have the authority to do this under Carcieri, and/or is there any other way to deal with it? I said to him that I knew that he couldn't hazard an intimation about the nature of the decision or any specific date as to a decision, but could he provide some kind of an outside time frame so that we might have at least something to work with as we go forward here? And he said, and this is virtually a quote, "I'm the guy that told you that the decision would be made by the spring of 2013, said he. So I have no credibility on the issue of deadlines, and I can't give you even a hint of an outside date. He said, I have no good idea of a date. He said, it's effectively, although it is nominally his decision, it isn't really his decision because he can only sign the underlying legal analysis, which has to come out of the solicitor's office. So that effectively it was not even really his decision. So he had nothing to add to any way for us to vet the timing of this. He did, incidentally, make a point of saying that he, on behalf of the BIA, appreciated that both the Commonwealth and the Commission had made an effort to try to be attentive to the legitimate concerns and aspirations of the tribe, but that he was also fully sympathetic with the broader issues that we had to deal with as well. So I guess on that score, the bottom line recommendation is, a recommendation from you all is that there's nothing to change our plans, and there is no information from Secretary Washburn that can inform anything that we're doing. I don't know how long you folks are planning on staying, but we're doing internal controls, and it's later on, I guess this afternoon. There may be questions that would
can
come
stay.
up, if
We can stay if you like.
that
Sure.
doesn't screw up your lives.
No, not
Okay.
at all.
All right.
Screwed up enough as it is. Yeah.
And next time, please bring your daughter. I want to meet her.
Yeah. No, talk about, no, I won't say it. Okay.
All right, thank you. All right, so that was the tribal half of part of our inquiry. There also was an economic part of our inquiry, and Commissioner Zuniga, who has led this analysis from the beginning, will pick it up here.
Okay, we distributed a short memo, but it's a summary from our consultants at HLT, who essentially, we asked them the same question. Has there been any of the recent developments, even some of the talk about other states, any of these would cause us to rethink some of the assumptions or analysis that was made as part of the initial market assessment. I'll jump to the conclusion, and the short answer is no. I'll elaborate, of course, but their market assessment is a framework that would still apply when we get to the Regency analysis. There is market out there for, from gaming in that region, and the assumptions that that were made at the time still hold true, because although the 17, that compact that Bob and Guy just mentioned, was signed on February, was approved by the legislature here on February 2014. The actual numbers were known before, because they had reached, the governor had reached that second agreement on 2013. And so the economics remain similar. I'm going to go through a couple of key points here. They get into those details here in the memo, but you might remember that there was a blended, a lower, a blended, and a high rate of gross gaming revenue per adult in the market areas. With a third or fourth casino, it would be relevant to take the higher number, and this is a bit of a supply meeting demand, or actually the other way around, demand meeting supply, and that is a relevant part of the analysis. It doesn't change much the actual, the overall, as I just mentioned, but it's a number that could be further analyzed. The biggest piece that remains the wild card, if you will, is the size and scope of the Regency Casino and commercial, and the tribal casino. And if one comes before the other, what does the second one decide to do in response to the presence of the first one? And which is, of course, by definition, a wild card. No one really knows how the other one is going to respond if the first one moves first. So we cannot get, our consultants cannot get to that analysis until we have first the applications, the applicants for the commercial licenses, and even then there will be an element of uncertainty because the response from the other casino, in this case the tribe, I'm speculating that we can get to the commercial first. In this case, the tribe may respond in a number of different ways. So they made assumptions, they clarified, even though at the time we picked Taunton as the place for the location of the market assessment in Region C for two reasons. It's both the geographic center, and it is of course where the tribe is proposing their casino. None of that changes the analysis. So again, even though they have not made a new market assessment, the reality is that, let me mention a couple of other things. The developments in Connecticut, for example, the talk as to whether Connecticut might expand its presence, or either one or both of the current operators decide to expand their room capacity, etc., would have a lot more effect on both Connecticut and Region B. In this case, they see that those kinds of developments would not have an effect on regions A or B. A or C. So there's a similar case to be made with what has happened in Rhode Island. They could still expand gaming there, but until they do, there's nothing to change or New Hampshire for that matter, there's nothing to change the analysis. Ultimately, what a lot of this means is it's up to the applicant to demonstrate and take the risk as to whether they want to build something there. Demonstrate that there's a case to us, we're in that position. And first, and even before that, agree or that they can still have an economically feasible operation, even with the risk of a casino, nearby. And once again, we cannot get to that analysis until we see the region, the phase 2 response from however many applicants we get, 1, 2, or 3, whatever the case may be. I can take any questions or comments on the.
Yeah, I personally was most interested in the surrounding environment, meaning New Hampshire, Rhode Island, Connecticut, New York. And from what you're saying, Commissioner, they've looked at that and do not see an effect on Region C, possibly another region of the state, but not on Region C.
That's correct. That's correct. Certainly not. I mean, the threat of expanded the gaming in New Hampshire was always there when we did the original market assessment. Actually, when we started, I remember. It continues there, and but if that happens, they don't see that as a game changer for Region C at this point. And a lot of the other rumblings about Connecticut really would have an effect on both Connecticut, which is important to notice, the existing operations, and Region B, and who knows if that's going to happen anyway.
So if I'm reading this correctly, and please modify me if I'm not, but it looks to me like in our outreach to our two principal consultants, one economic, one tribal, that the answer to the question that was raised by Commissioner Cameron is there really are no changed circumstances as of the moment that should cause us to change our plans. Does that feel right to you?
That's the report from both consultants,
Right,
and
right.
I thought that was an important update to have.
Right, and I agree with that. And as I said, because other people have expressed concern about Region C, I think it was fitting that we take a deep breath and take a look. I do want to make, so let me just be clear again, and again, if I say anything that doesn't sound right, please say so, but for clarity purposes, I want to walk through this. The plan that we have been on for quite some time now has been to go forward with the commercial application process. We have extended it in various ways, various times, because some of us at least have wanted to encourage competition, even at the expense of time. Speaking as one who voted for an extension last time, I'm doubtful that we'll be doing very many more extensions, maybe any more extensions. But the process now has been that we, with that 45-day extension, we complete the commercial process. At the end of the day, we will have at least one applicant, because we already have that applicant, and there may be one or more others. At the end of the RFA2 process, we will go through our customary analysis and evaluation in depth, and we will then conclude whether we have an adequate applicant or not. And we will assess the circumstances at the time, all of the economic circumstances, the cases that have been made by the applicants, their arguments about how they will deal with competition, just as we have had all of our applicants do in the past. And we will then determine whether to make an award, and if so, to whom. And that is the plan that we're on, and that's the plan that we're sticking on. We have never said we will absolutely make an award. We've never said that about any of the licenses. But we are now committed to continuing the commercial process and taking into consideration the applicants' arguments for why it makes sense to go forward with them as part of our evaluation, part of our decision-making. Does that sound clear?
That sounds right on point to me. And as one who voted against the extension and went back to review the transcript, by the way, because I thought it was important to me, my comments and reluctance about the economics were really in the context of the discussion that we were having and the vote that we ultimately took, which was to extend or not the deadline to the applicants that were incomplete, had an important piece missing, and and my comments reflected, my doubts as to whether they would obtain that equity. We indeed have one complete application and with an equity component, and as far as I'm concerned, them or anyone else would be in a position to prove to us, which is the whole process that we have set for here, whether and how they can compete, they can absorb risk, and they can provide a return on investment that would be sustainable. And that's been the rule for everybody in every region. It's we're once again looking at it on Region C.
Right. Okay, Commissioner Cameron? Right.
Yes.
Commissioner McHugh, you?
Well, I was just going to say, I said last time that I wondered if there were a way to make an economic decision early. It seems to me clear on reflection that there isn't, and that we do need to follow the process that we said at the outset of our discussions about Regency we were going to follow. And as both of you have said, that's the same process we followed in the other regions and with the slots parlor, and that is to take a look concretely at what is being proposed, where the sources of revenue are, what the projections are, and what the, among other things, efforts and plans for resisting competitive pressures are, and then make a decision as to who has the better, and assuming that both or at least one is has convinced us that it's a viable process economically. So I'm committed to that process and think that it's the one we ought to follow.
The only thing I would add is the suitability, which has been an important part of our process, and I know that that is, IEB is working on that as we speak, and I know they'll be as thorough as they have in the past, and that's an important piece of our evaluation as well.
Okay, I think we have dealt with this. It was time well spent. Thank you, Commissioner Cameron, for bringing it up, and we are moving forward.
Thank you very much.
Thank you.
Thank you.
Thanks very much.
The next item on the agenda was actually raised by me, so why don't I just skip right to this? It's Section 3B.
Chairman Crosby?
Yeah.
Could I just clarify, so the staff will return after the May 4th date to update the rest of the dates for Regency?
Sorry, say again?
We will just plan to return to the commission with proposed dates for the rest of Regency after the May 4th submission
Right.
date
Right.
for the
When
complete
you know how
application.
many there are.
Okay.
Right. It just occurred to me that a number of the commissioners, when we were taking our sections of the RFA2 application, we broke the application down into 5 segments. Each of us took a segment, and we worked, in most cases, with consultants and/or advisors to evaluate each of our sections. We all made some comments that on close analysis, there were some tweaks in the application forms and questions that we would like to have made had we had an opportunity. And we talked about how it evolved, it kind of evolved by cutting and pasting sections out of the law into the application form, and it was never really edited to be an editorially careful document. We do now have the opportunity to make some adjustments in the language and some of the questions, take out duplication, and my suggestion was that we do that, not change in any way the substantive categories, so that the primary reasons, primary evaluation criteria will remain precisely the same, but the form of the questions may change somewhat. And I just throw that out as a suggestion.
Yeah, I for one have a couple of instances where, having gone through the review of these complex and lengthy applications, we went back to applicants on a couple of cost categories, for example, to make sure that a certain cost was broken down or included in another category or et cetera. Out of that came what I think is a better format for certain template, the template for submitting costs, and that's the kind of tweaks that I had in mind. It's the same ask, a pro forma of all their development costs and a cash flow discounted at the same rate, et cetera, et cetera. But rather than going through an iteration of submit your cash flows and let us go back and ask you again, I would argue, let's make sure everybody has that template that we all took to do the analysis and have everybody have the ability to compare apples to apples. So I would certainly categorize, that as tweaks. It doesn't change anything, as far as I'm concerned. I keep thinking of the finance section, which I'm the most familiar with, and I would agree with that notion. Of course, the sooner the better, because our sense is that there's people already working on these applications because they are very lengthy and complex.
I'm more than happy to, my goal was to work with the folks who were outside advisors in the review of the economics section, go back, just relook at the questions, tweak them if necessary. Mr. Chairman, is it your goal to maybe be back here in 2 weeks with kind of updates or recommendations to those questions so we can move the process along as commissioners?
Well, it certainly would have to be done by May 4th, because May 4th is when the RFA2 deadline the RFA1 deadline is now scheduled, whereupon people will be getting their RFA2 form. So it certainly has to be done by then.
Okay.
And if there's anything in any way substantive or meaningful, I think we ought to talk about it here. I think if it's just editorial changes, we probably still ought to review it, but it wouldn't necessarily have to be within the next 2 weeks.
Okay.
And it's,
Yeah.
and it's completely discretionary. We can, we can do as little as we like on this, depending on each of our feelings about our sections.
Yeah, and I think that's to prevent heart attacks for those who've been working on it, underscore the fact that these are tweaks, and to remember that in processing the RFA2 applications in both regions and for the slots, we, on a number of occasions, reach out to the applicants for more information.
Right. Yes.
We reached out to the applicants for more information because it turned out that the way we'd phrased the questions wasn't yielding the information we really needed. And so it's based on that experience that we've thought about, and that the chairman has raised the thought that we should do more than just think about, revising the questions slightly so that we get that information initially and in a form that is most helpful to us, so we don't extend the review process by the reaching out and getting supplementary information back. We jump right to the end and get the information that we need without going through the intermediate steps. And I think that would be an enormously helpful process, both for us and for the applicants, and for the host and surrounding communities who have to take a look at this and understand what it is that the plans really are. So overall, I think this is a good approach, and that we ought to take until May 4th to think it through, or take whatever time up to May 4th we need to think it through and make sure we get it right.
Yeah, I would agree, and I think we could assist those who are familiar or maybe have filled out the application or are in the process by, as we do with many of our changes, kind of redlining the changes so people would know and not have to reread or interpret the whole application again.
That's right.
Right. Great. Okay, so we will work on that. The last thing, unless you had something else, Executive Director, I just wanted to thank the legislature and the governor for responding to our suggestion and request that they standardize the winnings level at which there will be a reporting, and in our case, a taxing requirement, moving it from the $600 threshold, which was originally in the law, to the $1,200 threshold, which is consistent with the federal government and the IRS and virtually every other state in the union, including our nearby competitor states. And the legislature has been reluctant to make any changes in the law because it was such a hard-worked law to begin with, but we appreciate the fact that they did this. They also accepted our recommendation that in Massachusetts, you will now be able to offset your losses against your winnings, so that you'll be taxed on your net gain if you have one, so long as you can document your losses. So you can't just claim that you got losses to offset your winnings, but if you can document your losses, you will be able to offset them against your winnings, which I think we all felt was a matter of equity. And again, I just want to express our appreciation to the legislature and the governor for adopting those changes.
I'll second that, and it was also a matter of competitive, and
Right, which is why it was done.
which is why it was done, and it was a big principle of the Gaming Act is to recapture gaming dollars that are currently leaving, and I, for one, thought that this was an aspect that was very important in that goal.
Right. Okay. Anything else?
I have nothing further, Chair.
All right, thank you. So we will move on, it now being, what, 11:30? Actually, you know what, let's take a quick break. Yeah, take a 5-minute break. We're ready to reconvene our public meeting 148, and we are at item number 4, Director Van der Linden.
Good morning.
Good morning.
Morning.
Good morning, Commissioners.
Good morning.
Morning, good morning.
Okay, I have 3 agenda items on the agenda today, and I'm proposing that we move one around, that we take the evaluation procurement first as scheduled, but then we discuss the claim management requirements second, so that Doctors Schaefer and LaPlante can stay for that piece, and then we will talk about the marketing procurement third.
You don't want to stay and hear us go through the internal control regs?
I'm very much looking forward to that.
Good answer.
Sure.
So first, the evaluation services procurement. The commission over the past year has adopted numerous responsible gaming initiatives. I think that in order to find out, are these initiatives effective? Are they successful? What is the quality of these? That we need to initiate a rigorous evaluation of those key initiatives. This is very true to the mission of the commission. and taking a look at the work that we're doing from a research-based perspective. On December 18th, the Commission approved the 2015 Gaming Research Agenda. Within that agenda was the evaluation of key responsible gaming initiatives outlined in the Responsible Gaming Framework. Those key initiatives that we identified were one, the play management tools on electronic gaming machines at the Penn facility or at Plainridge Park Casino. The second one was voluntary self-exclusion program, and the third was the Game Sense Information Centers. So we put that out for procurement, and on February 27th, the Commission selected the Division on Addictions at the Cambridge Health Alliance, or as they're referred to as the Division, to carry out these important projects. In your memo, I have a pretty thorough description of what is the Division on Addictions and what is their work. I won't read through that, but I will just tell you personally that I've been following their work for years. I've always thought very, very highly of it. In fact, when I was with the Iowa Department of Public Health, they reviewed the gambling treatment program, or problem gambling services for the state. It was an instrumental document in improving the quality of services for the state of Iowa. Another relevant touch point is they were involved, or they developed Your First Step to Change. That is still used by the Mass Council on Compulsive Gambling, a fantastic resource on problem gambling. So what is it that they're going to do? I will go through just a brief description of the evaluation plan, and then I'd like to talk about each of the key initiatives that they will be evaluating. So during the initial project period through June 2017, we propose that the division will assist the Mass Gaming Commission design program strategy, establish evaluation protocols, and provide preliminary findings and recommendations to advance 3 key responsible gaming initiatives. Pending consideration of the results from the initial period and improved by the Commission, the division may continue its research through 2020 in these areas, with the goals of establishing new features that advance responsible gaming and the long-term efficacy of key responsible gaming programs in Massachusetts. So I'm not sure how we want to proceed through here, but I would like to just, I would recommend that we talk about what are we evaluating. That was especially as important as we went through play management to what are the key program questions that we're attempting to answer. And okay? So the key program questions that are going to be addressed for play management is, one, is there any evidence from player records or self-reported information that play management could be harmful or beneficial? Second, do play management tools have the potential to be effective mechanisms for supporting affordable gambling and managing excessive gambling? Third, are there any characteristics, for example, demographics, gambling patterns, or preferences, that broadly speaking would differentiate those who enroll in play management from those who do not enroll? Fourth, what is the prevalence of gamblers enrolled in play management who trigger the messaging in the play management tools? And is that in triggering those mechanisms associated with behavior change? And finally, do enough people utilize play management tools to justify the related costs? And I think that fifth question is something that ultimately, with the information that we have from the Commission at the end of this trial, we would need to decide whether or not that indeed enough people utilize it, that it would be an effective tool that we would want to continue beyond the trial period and with our other licensees.
Comments on the questions, or have you finished your sort of introduction,
Yeah.
or tell us when you're looking for feedback?
I would propose that we discuss those questions, see if there are questions for the division on their plan regarding play management, and then move on to the next responsible gaming initiative to be evaluated.
Have these questions been run by by Penn? or the other licensees?
The questions, I forwarded the questions to Penn. I did not receive feedback, but granted it, they were forwarded to them.
I mean, there's no, these aren't necessarily set in stone, right? I mean, if during the course of the research it turns out that other leads ought to be followed or other questions are suggested by the preliminary answers, I assume this is plastic enough, or the concept is plastic enough to add other questions to that.
My simple answer is yes, but I would think that Dr. Schaefer and the plant would have a response to that as well.
So then my only substantive question is with respect to 5. Why is enough people the only criterion? Suppose we found that if you answered that question negatively, just on a quantitative basis, qualitatively there was evidence that the people who did utilize it were saved from significant problems that the research demonstrated those who did not utilize it encountered. Would that be a sixth question we could ask, or some kind of an offshoot of that? It seems to me that the quantitative piece is really important, and easy to get a hold of, because people may, as we've talked about, utilize this for reasons other than prevention of problem gaming. I mean, may find it an attractive budgeting tool and what. But even if they don't, there may be some qualitative component to it that makes it worthwhile to continue, even on a cost-benefit analysis, a different cost-benefit analysis. But so I just throw that out.
Yeah, I agree. I think that is a very important question to answer.
I don't know whether it'd be hard to answer, whether it's possible to answer.
I think it's possible to answer. Is it possible to definitively answer this question within this initial period between now and June 30th, 2017? And I think that's one of the challenges of this project, is to be able to get to that point at the end of this period, June 30th, 2017, and definitively answer that question to answer your question about the effectiveness of it. I think that it's going to be a decision point that the commission is going to need to make. Do we have enough evidence about both the uptake, which I think we will, and the effectiveness, which I hope we will, but perhaps not. The commission is going to need to make a decision about what to do next with that information.
Do you want to speak, Howard?
Or speak to that?
Excuse me, thank you, and good morning, everyone.
Good morning.
Good morning.
I think Commissioner
Your name and position?
I'm sorry, I'm Howard Schaefer. I'm the Director of the Division on Addiction. Commissioner McHugh raises, I think, a vital question that will overarch all of the other questions. Ultimately, it's really not about enough. It's about the pattern and how people use these devices that will give you information about whether you want to pursue the continuation of play management or not. And this comes up all the time. I mean, the very issue of gambling could be substituted in this item. I mean, the fabric of our community is determined by these kinds of decisions. It's not simply a scientific decision. We can tell you about how many people utilize this. We can even tell you about their patterns. But what the outcomes are will be, I think, a value judgment, and we're not going to make that value judgment. We're going to provide you with the information so you can make the value judgment.
When you say what the outcomes are, what do you mean?
Well, for example, excuse me, if people use play management tools, that might improve the quality of their life. It might decrease the quality of their life. It might be dangerous to their life. It might be totally enhancing to the quality of their life. We don't really have answers to this. No one's looked. So it's like the first stage of a drug trial where we want to make sure that it's safe, that there are no harms that accrue to anyone. And once we know that it's safe, then we can investigate more characteristics of the experience, but we can't really anticipate what they are. So, for example, if many people utilize the tools and some people had very adverse reactions to the tools, we probably wouldn't want to use them. I mean, that's what we do with pharmaceuticals. If the threshold, the lethal threshold is too low, we don't pursue those kinds of medications. But on the other hand, on the flip side, we might not have many people, but we might be saving lives. And our social moral obligation, our responsibility is to continue to provide that, even though on a financial cost benefit analysis, it's expensive, but it's worth it for the lives saved.
And in that scenario, isn't it inherently difficult to figure out, how many bankruptcies we might have avoided?
Yes.
Because, of course, they didn't went into bankrupt.
Yes. The question's a very complicated and difficult question.
Right.
It's even more complicated than that because the design that's possible, because this is something that's going to be live and people are interacting with it. It's in a business that's operating. So
Right.
we're not going to be able to randomize people to different conditions. We're not
Yep.
going to be able to say, okay, you get play management and you don't get play management. And based on those experiences, these outcomes suggest that play management causes this or that. So this isn't going to be a design that allows for causal statements, like does play management actually prevent bankruptcies? That's not something that would be practically feasible based on the information that we have. So it's a little bit, it's even more complicated. And I just want to say that I agree with Commissioner McHugh that I think that question 5 really stands apart from the other 4 questions, which really are getting at what is the evidence and the information that we will be able to provide through the set of studies that we're considering. And question 5 is distinct because it definitely does involve value judgments that I think the Commission is going to have to make some decisions about. You could make an entirely financially based decision, or you could go at it from a social responsibility perspective, like what we've been talking about.
What you're saying is that because this is entirely self-selecting, we don't have a control group that's identical to the group of self-selectors. But it still would be possible, would it not, to look, or would it, at what those who don't select this tool are doing in areas such as the average amount spent, the average length of play, the other financial characteristics of their lives as compared to those who do. I mean, those kinds of things you can do.
Yes.
Yeah.
And we've proposed looking at individuals who opt into the play management, but also those who use their player cards, but don't necessarily opt in, so we
Right.
can look
Right.
at the different behaviors.
Right.
Just to pick up on that note, because I had a question around question number 3, which you're looking for the characteristics of the folks that are going to use the play management from those who don't enroll. So it's people who have signed up and the people, well, everybody else. So are you expecting to use the player card information of the folks that aren't subjecting or aren't using the play management system as kind of the comparison group?
Yeah.
Yes.
Okay.
Yes.
Thank you.
I would say that it's not a true comparison group because it wasn't randomly assigned. You may find that the group that chooses to enroll has something that's fundamentally different, that would be different about them because by the pure nature that they enrolled in the play management system, they would differentiate themselves.
And I guess additionally to that question is, isn't it enough just to look at the characteristics of the people that are choosing? Is it enough to say, by June 30th, 2017, we know that our general makeup, or the preponderance of the makeup of the play management users are this group, and if we want to try to expand it to another group, we should look at how we do that. I guess I'm wondering how much of the research of the people that aren't using it is necessary if you're going to capture the information of the folks that are using it.
Well, we wouldn't know whether or not those are characteristics of play management or characteristics of players in general if we don't have a comparison to look at.
Okay.
Actually, I've heard Dr. Schaefer make this point, so but I'll make it. You know, the composition of the players that visit a casino initially or later is going to vary over time, and which is intuitive. You know, perhaps for just any other space, right? Retail or anything. So there's an element even over time here that is very important. And when they talk and allude about trends, it's one of those things that they will look at.
You know, I will be interested in the fifth question because, Director, you've talked about the fact that in places where this has been tried, there was an issue with people using it, and one of the areas is it was never marketed, correct? So this will be a better effort to get people to understand it and to possibly try it. Is that?
I think from the onset that our strategy for uptake and education about the tool will be far greater, and that extends through when we talk about what types of incentives can we provide, how do we leverage the GameSense brand to market this as a responsible gaming tool. I think that both of those are going to be key. And I look forward to working later on our agenda, working with more advertising to talk about that as well.
Just in the second part of this, you talk about the two phases, study 1 and study 2. In neither one of them is there any reference to any of this qualitative stuff. The phase 1 is the epidemiology of those who subscribe, which I understand. And then phase 2 says examine the issue of uptake, and it's basically, you know, can you use other tools to get more uptake? There's nowhere in between in study 1 and 2 anything about the impact, you know, assessing the you know, behavioral responses and is there a positive impact that would inform these qualitative questions? I mean, I guess you wrote this.
You wrote it, yes.
You wrote it, but I'm
There
assuming
is.
it came from them.
You know, and this goes back to this issue. I won't call it a problem, but I'll call it an issue. Given the initial project period through June 30th, 2017, what will we be able to find out? In the original plan that was submitted by the Cambridge Health Alliance, it was a I think it was a 5-year plan that really did dive deep into that very question. We talked about truncating that, making it a briefer period of time, and when in discussions with the Cambridge Health Alliance Division on Addiction, what will we be able to know after? Realistic will we be able to know after this period of time? And this is what we'll be able to know realistically within this period of time. Will we need to extend it in order to gather more information to conclusively answer that? I would say it seems likely at this point that we would.
But doesn't that become a decision point as well? Do we have enough information at that point to make a decision that though we need more information for definitive answers, the cost, the information that we do have justifies imposing the cost of installing this on the licensees, or doesn't? And if the answer to that is no, there's no reason it can't continue on the pilot basis and then make a decision as to what to do if the information yields positive results down the road.
Yes, that's correct. I mean, stepping back from this, we are moving forward with a pilot pilot test basis with PIN, because when we laid out all the information about what we know about this in front of us, we said, it's just not clear, one direction or another. But in prescribing to a precautionary approach of the framework, we said, yes, it seems like there's enough promise here, enough evidence that this can be an effective, responsible gaming tool that we want to test it out. But we're going to do it. We're going to evaluate it. We're going to evaluate it. And so this is exactly what falls within that precautionary approach for this specific tool. And I think that we have clearly the best in the world, I would argue, to take a look at this, and we will know what we will know at the end of that 2-year period. And another piece of that is we wanted to do the best evaluation that's been done on this. That when we laid that evidence out in front of us and we took a look at it, there was problems with the methodology of every single study that had been done on this, and we are taking our time with it to conclusively answer some of these questions, or at least take us down that road to certain decision points about whether or not to continue it or not, or abandon it.
Let me pick up on that comment of taking a step back. And I think it bears mentioning that there's a lot of great, I'm very excited because there's a lot of things that have converged to this point to effectively do this. PEN coming online, agreeing and having a system that supports this play management suite of products that Bally makes, comes online 2 years prior any other casinos. I mean, in an ideal world, somebody could have designed a clinical trial on a lab, but we don't have a lab. We can have the best use of what we have, with your help, obviously, and the cooperation of PEN and Bally's, etc., to effectively allow us to get information, whatever we can do, whatever we can get, up until incremental decision points. So I think I for one, I'm looking forward to this evaluation in general. Just having that process is very important to me and to us. Looking back and making decisions based on real evidence, scientific processes, wherever we can implement them. And I'm excited that we're embarking on this effort.
Yes.
Has DOA read this? I mean, they have this, right? This is jointly produced, I assume, right?
Correct.
Okay. So I understand that your optimal term was a 5-year term, and I understand that there's going to be limitations of what we get out of the first 2 years, no question about that. But I know we also made it clear that we have to know as much as we possibly can in order that we can make that eventual no-go decision. And you have laid out 5 questions that you will answer to the best of your ability during that 2-year period, which includes, do they have the potential to be effective mechanisms for supporting responsible gambling and so forth, and do enough people utilize it, to warrant the costs? But just in the write-up about study 1 and 2, there's only the epidemiological analysis of uptake and usage, which stops after the first year, and then study 2, which only talks about the issue of uptake and are there better mechanisms for increasing uptake. I don't see anything in your study 1 and 2 that gets to the question of, are these tools having a positive effect? What am I missing here?
I think the challenge for all these questions is going to be the uptake itself and how many cases are available to look at. That if the numbers are so small, we may not be able to answer some of these questions. But if the uptake's large, we should be able to answer all of these questions and give you the information you need to make a decision, for example, on number 5.
Okay, well, all I'm saying is that there's no reference to a study of, there's no reference to a study of those people who have subscribed, who are utilizing the tools, and the impact that it's having on their behavior and their awareness of it and their their own personal beliefs about whether it's working or helping and so forth.
No, I don't know whether it didn't get translated into the memo, but that first study, the epidemiological study, will rely on both on the information that we can get from Penn related to their actual gambling behaviors, but also will coordinate with them to do survey-type work so that we can have a better understanding of what the different gambling patterns that we can observe through the behavioral data, how they map onto different experiences that people would report. We also can ask them questions related to what are your perceptions about how the play management system has impacted
Right,
them
okay.
and whether they're
All right.
satisfied with it and whether they have perceived among themselves any harm or, personal damages or anything like that.
Would study one run the full
That's-
2 years?
Yeah.
Okay, all right. I didn't get that.
Yeah.
You do use the word survey in here, but it sort of got lost in the shuffle. Okay, fine.
Yeah, there's a high amount of iteration in this that I glean from this. There's a lot that that we may even learn even before the 2 years that could help inform uptake.
Yeah.
It could help inform, just the font of the messages, the tone of the messages. This is experience our researchers have in another setting can have different results.
And that's the explicit purpose of study too.
Yes, yes.
That's a really great point. There's a lot of work up front that are the nuts and bolts of what this looks and feels like. What are the messages? How do we communicate those? That is a really complicated process, and that is another part of, it's not just evaluating what we have out there. This is going to be a process of developing that and then looking at the effectiveness of that over time, and making changes to those initial requirements as well, to see what impact that has. I'm thrilled to have them on board to do that.
Yeah, that's great. I agree. Anything else?
Should move on to the second piece of the evaluation.
Yeah. Do you need,
self-exclusion.
you don't need anything, you don't need a vote from us, I guess, or?
Well, I
Not
was
yet.
going to propose a vote at the end of it, since this is kind of a package that they are.
Okay.
A package of all three evaluations.
Oh, I'm sorry, of course, yes, I'm sorry.
So the second piece of the evaluation is voluntary self-exclusion. And voluntary self-exclusion is required in statute, that we have this program. Voluntary self-exclusion, basically that individuals who are experiencing gambling-related problems and don't feel that they have the sort of internal controls to manage that have an opportunity to implement an external control on that by signing up for a voluntary self-exclusion from the casino. Basically, it's an agreement between the individual and the operator of the casino that would say, I don't want to come back here, I don't want to be allowed in. There are disincentives for them to come in, including that they would basically be trespassing, they would lose any of the winnings that they would have if they do come in. This is a type of program that basically any state that has gambling has some version of the self-exclusion program. And so when we implemented this requirement from the statute, it could have been relatively straightforward. We adopted what we call in the framework in what we have reflected in the regulation in engaged approach to voluntary self-exclusion. Voluntary self-exclusion can be basically an administrative task in which the person signs up and their picture is taken, their information is taken, and then they're escorted off the property. We would like to have an engaged approach in which the individuals that are administering the self-exclusion program have specific training on understanding what the individual who is coming to them may be going through. They have training on how to do a very brief intervention that would open up additional treatment opportunities or help opportunities for them. Not mandated, but an offering for them to access those, and perhaps even a warm handoff, meaning that an appointment would be set up if they so choose. We're working on some of the details of this engaged approach with well, we'll be working with the division as well as the Mass Council on Compulsive Gambling to decide what that ultimately looks like. So what is the effectiveness of, well, one is what is the effectiveness of self-exclusion, or voluntary self-exclusion? And two, what difference does it make that we as the commission have adopted this type of engaged approach to voluntary self-exclusion? So that led to the questions that we have here, which is, does an engaged approach to voluntary self-exclusion improve the likelihood that participants will seek additional help for their gambling-related problems or more general mental health issues? Does it decrease gambling behaviors? Does it decrease the likelihood of violating the voluntary self-exclusion agreement? And finally, does it increase satisfaction with the self-exclusion program, and more specifically with the enrollment process? And finally, are players, and this is a separate question, but also could yield some very interesting information that has programmatic implications. Are there player behavior markers that can predict entry into the voluntary self-exclusion program? So that the evaluation plan leads to answering these specific questions.
Questions?
Yeah, Director, I know that most jurisdictions that have casino gaming have this program. Has anyone studied it this way? Does anyone really take a look at evaluation of the program?
Well, Debbie LaPlante is probably could probably best answer that. The Missouri program, she evaluated, but to my knowledge, very few other evaluations have been done. So I think Dr. LaPlante can speak to the Missouri evaluation. Correct. So was it Dr. Nelson that did the Missouri?
Yeah.
We all
Both
did that
involved.
study.
You
We
were all
were all
involved.
involved in that study. There have been a few evaluations of voluntary self-exclusion, more than a few, but none in a randomized clinical trial like we're proposing here. Typically, people have been followed as a cohort, and when you follow them as a cohort, you discover that after a bit of time, about 50% of the people will have returned to gambling in some way, either on the property from which they were excluded or on other properties. There are shorter-term benefits, and the benefits tend to decline over time. In terms of an enhanced or an engaged approach, there is one paper that I'm familiar with from Canada, and in that paper, everyone reads them differently, reads these papers differently, but my reading of the paper and my takeaway point from the paper was that in the enhanced approach, those who self-excluded tolerated much more than scientists and public policymakers would have thought that they would tolerate without that study. So there is a sense that many gamblers who self-exclude as a device, as an instrument to help them gain some sense of control. And in order to do that, they sign on for all kinds of different things. In the early days of voluntary self-exclusion, for example, it was a lifetime ban. And people have discovered that actually repelled people from the program. They didn't want to commit for a lifetime, but they would commit maybe for 6 months or a year. So then we saw the times change. And now Dr. Ladouceur from Canada has suggested, I think he was the first to suggest an enhanced program, is suggesting that if you add many other characteristics, maybe we can do much more for people who sign up for these programs. Interestingly, the results weren't overwhelmingly improved, but they did suggest that more people would go into treatment and more people would pursue other limits than they had before and than we expected.
Is the enhanced piece what Mark was describing relative to a trained person that can administer a short test and make a referral if necessary or inform, et cetera, et cetera? Is that
Yeah, I
the
would
gist
say
of it?
it's similar to what Dr. Ladouceur
Right.
implemented. Was it I can't recall where in Canada we implemented that program.
It doesn't matter.
I don't remember.
Wherever.
The goal is not to increase barriers to
Yes.
and I'm consciously aware of that at every step. What are we doing that may create additional barriers or burdens on an individual to access help? And I think that no matter what direction we go with any of our programs, we need to look at what the barriers are. And so the enhanced version is not intended to create those.
Understood.
What do you get with question 2?
The question 2,
What do you,
are there player behavior markers that
Right.
can predict entry into a self-exclusion program?
what do you,
So that would give you information that somewhere down the road potentially could be used to help develop some type of an early warning system in conjunction with people who are using a player card. If their player behavior starts to take on characteristics that look like they might be at risk of going down a path where they might feel the need to self-exclude, there might be something like a warning message that could be delivered to them in some way. But it really is kind of a planning for the future type of information. It's not something that we would be developing intentionally through this project right now.
right. Okay, great.
I have just a couple of questions about the regulation itself. So the regulation anticipated that we would be evaluating this, and it's built into it that we would be doing that. The regulation did not anticipate that we may be doing a clinical trial where we would be doing a standard type of enrollment versus the enhanced enrollment, and I'm wondering what implication that has on the regulation itself, whether that needs to be revisited. In essence, it remains the same, that the durations are the same, but the sort of initial process look slightly different, where somebody may receive basic information about the self-exclusion versus the possibility of the enhanced piece.
Well, we could always look at the regulation and see if it's flexible enough or constraining enough that can sway us one way or another. So I would table that for the next time, and let's assume that it works for now.
Just a question for you and Todd to look at it.
Right.
You tell us.
Great, we will.
And if we need to change it, we can change it.
Okay, so the final component of the evaluation and initiative that we're taking a look at are the GameSense information centers. And similarly, there isn't a great example, definitely in the United States, for us to take a look at of what is the model that we should be following for this. We're following the general model that the British Columbia Lottery Corp used when setting up their GameSense information centers. But it will be interesting to see what effect these centers have in Massachusetts. So the program questions to be addressed are: what are the characteristics of GameSense information centers? How much traffic does GameSense information center receive? What are the reasons for the visits? Who uses the GameSense information centers? The second question is, do the GameSense information centers provide appropriate and satisfactory responsible gaming services? Are the visits associated with a self-reported increase in gambling-related knowledge? Does the GameSense information center promote a sharing of gambling-related information? Are the GameSense advisors seen as caring, helpful, and knowledgeable? And do patrons feel the matter for which they visited the GameSense information center was resolved? It's not. I think that this is going to be an interesting evaluation that also similarly can evolve over time as we see these centers kind of take on their personality. And we may have additional questions that we want to add to that.
Mark, it wasn't related to one of the questions, but further down under your evaluation plan, it talks about how important it is important to determine how the properties implement the GSIC. Help me understand that phrase.
We as the commission, through through the Mass Council on Compulsive Gambling, are responsible for the implementation of these game sense information centers. And I think that there is a philosophy that we are advancing these centers with a number of different activities, the general look, the feel. When we talk about are the game sense advisors seen as caring, helpful, and knowledgeable, that this is something that we're specifically looking to create in a game sense center. That's difficult. It's difficult to translate from one casino to the next, and I think that we want to pay close attention to make sure that we really are achieving this philosophy that we've established from the onset.
Okay, but the way it phrased led me to believe that it's really up to our licensees in implementing the GSIC, and it's really a collaborative effort.
Right. It's our licensees are going to be important partners in this. And this is it's led by our game sense game sense advisors. It's in partnership with our licensees. That this is a resource for our licensees, and how we can work in collaboration is going to be very, very important.
But our game sense advisors are going to be working for the Mass Council, right?
Correct.
So you haven't mentioned that, but the Mass Council, I think, has the lead obligation here to make sure that these people are properly trained and doing what they're supposed to do, and that it's constant across all facilities. I mean, we'll be a party to that, and so will the operator, but it's the Mass Council's job.
Correct.
You mentioned surveys in the, which make intuitive sense, of course, but would that include employees of the casino, for example? Sometimes there's great intelligence that they could gather as another party, not just the patrons or those who visit the game sense information centers. Do you have a reaction to that, or that's a little too much into the weeds?
Well, I think it's a fantastic idea. When I say it's really important that we have a positive relationship, and that we're seen as a resource to the casino employees, it only makes sense that we would add that as a way that we need to measure that resource or value to them.
Right.
Is there a need to measure the physical characteristics of the game sense information center?
Physical, what is the look and the feel of the game sense information centers? I would say.
Is there a value to that in terms of understanding why people come in or don't choose to come in?
I would say so. When we first introduced the idea of game sense, what we said is we don't want it to appear as this heavy-handed approach from the government. We want it to be helpful. We want it to be welcoming. And this is as much, it's led by our game sense advisors, but we want the look and the feel of the game sense center to strike the right tone. And so I think that part of the evaluation could be what people's perception of the game sense the physical environment of the game sense information center too. We have a lot of control over that.
Dr. Schaefer,
I agree with Commissioner Stebbins. We should be asking that as part of our evaluation so that we have a sense whether it is welcoming, et cetera. So I agree with that. I also wanted to add that we would expect that employees would use a Game Sense Center. It's not a customer-only kind of environment. It's an environment to help people understand gaming. And our experience in many other settings is that employees are eager and interested.
Great.
Director, there's a 1-month training coming up for our state police, local police, gaming agents. Is this something that we have thought about introducing and making sure they're fully briefed on this concept and the values?
They will now.
Right now.
I think.
I'm sorry, Commissioner, I hadn't, but I think that it's a great idea, and we can, especially once we have the Division on Addiction on board and the Mass Council is working on this, we will certainly roll that into it.
Great.
Thank you.
Anything else? Did you have something else? Okay. Okay?
So my recommendation, the proposed evaluation study will provide valuable information to advance responsible gaming initiatives adopted by the Mass Gaming Commission. I therefore recommend the Mass Gaming Commission enter into contract negotiations with the Division on Addiction at the Cambridge Health Alliance to conduct evaluation of select responsible gaming initiatives. A final contract would be contingent upon approval of the Public Health Trust Fund Executive Committee.
Do I have a motion to that effect?
Sure, I will move, Mr. Chairman, that we authorize staff to begin negotiations and enter into a contract with the Division on Addiction relative to the evaluation plan for the 3 aspects as presented here in the packet.
Second.
Would you be willing to add that last sentence as well? I think that's important.
Sure. A final contract would be contingent on the approval of the Public Health Trust Fund Executive Committee.
Right. Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Good.
Thank you.
Congratulations.
Thank you very much.
Thank you.
Thank you.
So said we'll move, skip to item C, which is the play management requirements on electronic gaming machines. Alluded to this earlier, but this has had a long journey in before the commission, specifically play management and how we have decided to move forward with this. So with that, I just want to give a brief overview of how we got to this point before I talk about what were the requirements that I'm presenting before you. So in September of last year, the Responsible Gaming Framework was adopted. It held out specifically, there was one piece of the framework that was held out, and that was the play management tools, because we felt that there needed to be further evaluation of whether or not this was something that the commission wanted to move forward with. After doing that, and in December, the commission approved play management on a test basis with PlayRich. It would be a trial, and that's where we obviously put a high priority on making sure that as we move forward that these are thoroughly evaluated. It then led to a curious question about whether or not, given that we have adopted these, that it would be required that we would want to move forward with this as a regulation, whereas we would say that since this is a test, that we would want to just create a list of requirements that we would want to move forward with. It's further complicated by the fact that this is a test, and we're going to evaluate it, and it's likely going to change through that test period to test different elements of it and to see what pieces of it are most effective and how we can adopt and adapt that specifically. And so it's recommended that we do not move forward with a specific regulation on this for that reason, but that we move forward with a set of requirements that would be agreed upon by PIN, by Valley Technology, who is the casino management system for PIN, and where the play management tools would live and how it would be presented. It's also important that our evaluators are on board with the initial set of requirements. So that was the first piece of it. And so as I present this to you, I'm presenting it not as a regulation, but as a set of requirements. On February 27th, we had a very good meeting with PIN, with Valley Technology, with Cambridge Health Alliance Division on Addictions, with the Mass Council on Compulsive Gambling, one of our consultants, Dr. Jeff Murata from Problem Gambling Solutions, and several of us from the Commission to review the requirements or the proposal that was adopted by the Commission and further iron that out and fill it out. And that's the result of that is being presented before you here. So what I have is a list of play management requirements. This would be translated into specs that would be rolled out onto the gaming machine. And as I say, that I want to emphasize this too, that these are the initial requirements, and that these requirements will likely change during the test period as we gain more information. We want to make sure that Ken is on board with it. We want to make sure that it's feasible and feasible with Valley, that it makes sense that we can measure it, and that we ultimately, at the end of this, have a clear answer to the question about play management.
I actually have a couple of questions on this. Is this a good opportunity?
Yes, yes.
There's a couple of instances where it says that a web-based option will be explored. First in the player enrollment, and then maybe later suspending participation. Do we know if there's development from a software perspective needed for that?
I think this came up in the requirements that were that the commission moved forward last December. It was originally envisioned that there would be a web-based option. In the meeting on the 27th of February, Penn indicated that what they have is basically a static system, that there wasn't the option to enroll and make changes. It wasn't an interactive process. So that at that point,
Penn or Valley?
Penn, I'm sorry, Penn.
Okay.
And so it wasn't feasible at that point in time. It makes a lot of sense that if our ultimate goal is to allow people to make decisions about how much they want to spend before they sit down at a slot machine or before they start their gaming session, that you would give them the opportunity to do so even before they enter into the casino. And so it still seems like a right course, but recognizing that the technical difficulties of doing that may delay the implementation of this. I didn't want to lose that piece of it, though.
Okay.
Mark, just 2 quick points. First of all, I thought this was very well thought out. Appreciated the progression of, changes, updates, things like that. And I know you were thinking along this line as well, but as you're doing things like game message changing and things like that, I hope it's your intention to somehow find a way to communicate updates, changes, et cetera, to Penn. They are our partner in this. That was something I just saw missing, but I know it's something you would be doing. And certainly as your thinking progresses in terms of the incentives for enrollment, I'm curious as to getting updates on that as well as you move ahead.
Definitely. I've had conversations with Lance George at Penn regarding messaging. He's obviously very, very involved and wants to have an active role in messaging that would go out to would be presented on the actual electronic gaming device or slot machines. And so we would include him in that too. Wherever they want, however.
Absolutely.
And those incentives are non-monetary, non-gaming credits, in other words, incentives, right?
Yeah, that is not envisioned that they would be gaming credits.
Yep.
But it does say the incentive for enrollment will be credited to the player's MR card. What does that mean?
We would, the marquee reward card.
Yeah.
But it doesn't necessarily have to come in the form of a gaming credit. It can come in the form of food credit, other types of credits. There are incentives that may be involved in the marquee reward card.
Okay, so their system is flexible enough to take in our incentive and put it onto their marquee rewards card.
That was what we had agreed on the meeting on the 27th when we talked about it.
Okay, I see some nodding heads from Penn. All right, thank you.
There's another question that I had, and I just remember numbers easier than other things. But the 25% threshold, I don't remember talking about that. The messages, was that something that
That was a
You guys-
change relatively
Okay.
recently, and in discussions with the division.
Okay.
Specifically, Dr. Schaefer advocated for us to reevaluate what those percentages were
Mhm.
as we initially rolled this out, and so they were reflective of that recommendation.
Great, fair enough.
This is great.
What is the schedule, Mark, at this point? When are you anticipating that we will start to enroll people?
I still have, and I hope it's not I would love to see this rolled out when Penn opens up in June. I think that that's an aggressive timeline, considering the decisions that we need to make. We've been working actively with Valley on some of the issues, the background issues of this, including what does the kiosk look like, and we've been working with Penn on number of kiosks and where they could potentially go. There are a lot of issues to iron out. I still have hope that we can initiate this on their opening day. But I would say that given that, I don't have a definitive answer that
Okay.
that's true, that we need to be prepared that it would start at a later date. We want to make sure that the rollout is beautiful, as smooth as possible. So that's the highest priority to me.
Right. Okay.
Great.
And at some point, I think you're going to want to get that date set and then do your critical path chart backwards, for all the same reasons we do that on everything else.
I'll work with Director Day on that.
All right. Okay, great. Do you need something
Do
from
you
us?
need action from this?
I would recommend a vote. We could just,
It says-
these are, I guess they are different than what the commission approved in December, and given that there are changes to that we are moving forward with requirements as opposed to a regulation, may make sense.
Fine.
Mr. Zuniga?
I'll be happy to move that the commission vote to approve the play management requirements on electronic gaming machines as presented and discussed here today.
Second?
Second.
Further discussion?
Does that discussion piece of the motion include discussion about modifying these if modifications prove desirable without coming back to the commission? And so long as the four participants, the commission, the researchers, Penn, agree on the modifications. That was only three, there's a fourth one.
Valley.
Valley.
I would say, my suggestion would be that, that be included, but that you always report back to us, but you don't need pre-approval from us. Okay? Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Good work.
Thanks.
Thank you.
Thank you, folks.
Thank you very much.
Thank you.
Thank you.
Yeah, thanks very much. This will be very interesting.
Yeah,
And thanks to Penn as well.
We
and
got one more.
Thanks to
Yeah.
right.
We got the marketing selection.
Yeah, Commissioner McHugh just said this a little bit under his breath, but
No,
I think, yeah. Let's say it again.
Say it above your
Say it
breath.
louder, yeah.
Thanks to Penn and thanks to Bally as well as to Dr. Schaefer and Dr. LaPlante and our own staff that's been working so hard on this. This
Right.
is really going to prove, I think, to be a very valuable first, and we're grateful for the cooperation.
Right. I can't thank Penn enough for their willingness to collaborate with us on all of these initiatives. It would be impossible without you. Much of these are not done routinely, and you've been terrific partners on this. You deserve credit for that.
I agree, and they have done that on a very tight time frame where they have many other priorities as well, and are working hard to achieve them, so.
Exactly. He's still beaming from the change in the reporting requirements, so.
Pardon?
I said Lance is still beaming from the change in the law with the reporting requirement.
Oh,
We need to harness that.
right. Next up.
Okay, next up is the marketing services procurement, and I have a memo for you, and I this morning noticed my typo that says that it's the evaluation service for procurement, but if you can disregard the purpose as stated in the RE section at the top of the memo, it is the marketing services procurement. I have with me Deborah Giddens from
Donna?
Donna, I'm sorry.
It's okay.
I drew a complete blank, I apologize. Donna
No worries.
Giddens from More Advertising, and also Elaine Driscoll, Director Driscoll. And we're going to talk this out. So the Gaming Commission on December 18th, similar to the play management, voted to adopt the GameSense brand to promote responsible gaming education, tools, and information centers in Massachusetts. In order to localize this brand and maximize the potential of GameSense in Massachusetts, we sought to obtain the services of a marketing firm. The initial scope of the services, just defined in the solicitation of this, were to modify the existing GameSense brochures and materials with the MGC logo. I want to back up and say we adopted this from the British Columbia Lottery Corp. And while very successful, beautiful campaign, it's a campaign that was rolled out some 4,000 miles away. So that's the purpose of this. Second, we wanted to plan and negotiate the distribution of materials in the Plainville and surrounding areas and elsewhere as directed by the Commission. Design and develop a GameSense website, develop brand materials to support the GameSense information centers, plan and negotiate media buys, and develop the GameSense social media campaign. On February 12th, the solicitation was released to a limited number of qualified firms from a statewide master agreement. Following the competitive procurement process, More Advertising was selected by the procurement management team to carry out this project. I'm not going to launch into a lot about More Advertising, but I will tell you what really impressed me about their application. One is their attention and dedication to health issues in their advertising strategies or portfolio. A second was their attention to paying attention to what the essence of our campaign was really about, and being able to come to the table to discuss that and bring some very creative ideas. And I think that I look to their experience in health campaigns, their creativity, to being able to work with them to really maximizing the GameSense brand. So I wanted to, Elaine, do you want to talk a little bit about the plan and budget?
Sure. Well, let me just reiterate what some of the deliverables are that you'll be seeing in the next few months, because I think that we'll be discussing those a lot, and I just want you to be aware of what those are. So prior to the opening of Plain Ridge, just so that we're clear, the immediate preparation of collateral materials to localize brochures and things like that. Very important will be the development of the GameSense website, which for Donna and her team will have to be done really quickly. And also what's very important will be the media buy prior to the opening of Plain Ridge. One of the reasons why that is so critical is because the onus is really on us to establish some brand recognition of the GameSense program, because to your point earlier, once again, Plain Ridge has been terrific about their obligations to assisting us with the GameSense logo and all of their collateral. The complicated issue that we have while they're, as you can imagine, sending a lot of their marketing materials to print now, given the close opening date, is that the GameSense logo will be on all of their collateral. The issue being is that we have to actually establish what that means for the audience, because at this point, it's an unknown. So we'll be working really hard to do the work that we need to do so that there's some brand recognition on a larger level. And then the other important deliverable as well will be the brand materials that will be on display inside the GameSense Center. Mark and I have already been having a lot of really great conversations with the designers of the GameSense Center with the help of the Penn folks. And then also the assistance of developing a really strong digital strategy, knowing that that's one of the most important ways that we can be communicating GameSense and building the brand. So, Mark, do you want me to go into budget on the ad buy, or?
I could do that.
Okay.
I had a question, actually,
Sure.
Elaine. Remind me, the digital strategy, is that Facebook, Twitter,
Exactly.
everything else?
Exactly. So
in addition to
social-
the web,
that's right.
social media?
Social
etc.
media, that's right.
Sure, I can talk about the budget. So we broke it into two pieces, a phase one and a comprehensive. Phase one really is, as Elaine had talked about, just really getting this out there and achieving those deliverables. In doing that, we established a budget of $235,930. Roughly $130,000 of that would be strictly in media buys to roll this out in the southeastern Massachusetts market. The rest of it would be all of the direct and indirect expenses, including website development, reproduction of materials, developing the media. I don't have the right word for
Production.
that. Production.
Yep.
Sorry. So that basically outlines how that's broken down. And Donna, if you want to talk a little bit about the media buys and
Sure.
the considerations for those media buys, that would be great.
Great. First of all, thank you very much. I'm pleased and speak on behalf of the MORE team. This is exactly the kind of work that we like to do, focused on issues and causes, and responsible gaming is really important at this stage of the game. So taking the GameSense brand and being able to retrofit it and fit it to what Massachusetts is doing is really important. So as it relates to the media buy, $130,000 will be spread across cable, outdoor billboards, of course, using the GameSense brand and the Mass Gaming Commission. We have to figure out if it's going to be GameSense Mass or Mass GameSense. Those are the kinds of things we'll be really discussing and focus testing, in fact. I know that we had that conversation, the focus testing of the concept with a particular audience will really help. And the media will be directed toward the southeastern Massachusetts communities, as Mark mentioned.
The original budget for marketing and advertising was approved by the commission was $450,000. By adopting the GameSense brand from British Columbia and still having a really aggressive rollout of this brand in Massachusetts, that we still had a considerable savings from the original budgeted amount.
Questions?
I'm just curious, and first of all, I enjoyed reading more about your agency and the fact that Mark pointed out this kind of fits in your portfolio of the type of business that you do, and we're happy that the commission is kind of practicing what we preach and soliciting a registered MBE to help us do this work. In terms of the media buy, it kind of occurs to me that Penn is going to have, the monopoly on the market for a period of time, and we're going to be drawing people down from the Boston area and from other regions of the state. I guess my thinking is, why would the media buy maybe not fan out beyond the southeast area, and wonder if there'd been any discussion about that, or your thoughts or ideas on why in this first phase just keeping it limited to southeastern Mass.
Want me to-
Budget drives a lot of that, I understand, but
Yeah, so Commissioner, I would say we have actually been discussing that point at length. I think like we do with a lot of the other initiatives that we're taking on at this point, we view this rollout as a pilot program as well. So given what we currently have in the budget, focusing that attention surrounding the Plain Ridge area seems like the best way to go at this point, and we'll have a lot of really good market data soon that will basically feed the decision on what that buy looks like exactly. So we haven't quite gotten that far yet, but we're confident in that we'll have really good demographic numbers that will be able to give us a very targeted media buy.
Okay, good.
And it's, you're currently working on the next year budget, are you not? So we'll have, the opportunity to have a little bit more of that discussion for fiscal year 16. But I get the initial point. Another thing that I would be looking forward to is and I know you've had these discussions or thoughts, having connections and ties with key stakeholders. For example, the Mass Council, if they can, and I'm sure they would agree to this, have a link to the GameSense website in their website, or that kind of cross referencing, or send out Twitter blasts to their own followers, just like we do, is the sort of thing that I would hope go a long way. In addition to Penn, by the way,
Right.
we will ask that they eventually put a GameSense logo somewhere visible and in the stuff that they market. Would go perhaps a long way towards that goal of establishing that presence.
Yeah, several
further.
of their marketing pieces have already actually gone to print with GameSense logos on them, because we're doing our best to accommodate their deadlines, but not miss the marketing opportunity, because that's the other great thing that we have here is the ability to really amplify the brand by being able to leverage everybody's ad buys.
Is the 130,000 enough to have a reach and frequency within your target audience that matters?
Well, I mean, we feel that it is for this first phase.
The GameSense brand is broad, and I think one of the challenges is to say GameSense, we're rolling out GameSense, and it's really about promoting responsible gaming, but it's also about heightening the awareness of resources and of gambling problems. And so we are certainly partnering with the Mass Council, and we've had those discussions with them about how do you brand this and how do you make those links and connections. And the council runs the statewide 1-800 helpline for problem gambling. It's not just the council, it's nationwide. There's been a decrease in the use of 1-800 numbers, so people are accessing information and help and resources in other ways. And so we're paying really close attention with GameSense information centers to what are alternative ways that people are accessing help. And we will pay very close attention to how the GameSense website is built to make sure that in the spirit of reducing barriers for people to access help that need it, that we look to ways to streamline that as much as possible.
Donna, what do you consider the biggest challenge of this engagement?
The turnaround time. But we're used to that. We're used to taking a project that needs to be crafted very quickly, getting it up and running. But at this point, that is probably the biggest challenge.
Makes sense.
I mean, the good news is that you have GameSense already. We have the brand. So it's a matter of, testing it out with the specific stakeholders, get their feedback, being able to incorporate that, and then get it up and running.
Converting the TD Bank green over to
Right.
Mass Gaming.
And get people to stop saying the Boston Garden. Never.
All right.
Mr. Chair, I'd recommend the MGC authorize staff to enter into contract negotiations with the More Advertising to implement a two-phase multi-channel branding and awareness initiative designed to introduce GameSense to the Commonwealth, and a final contract is contingent on the approval of the Public Health Trust Fund Executive Committee.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you very much.
Thank you.
Congratulations.
Thank you.
Thank you.
Glad to have you on board.
Look forward to
Thank
working
you.
with you.
All right, it is 5 minutes of 1. Why don't we take a break till 1:45 for lunch, and we will reconvene at that point.